Okay, I am going to rudely interrupt your lunch, but not your eating. Because what's going to happen now is an open meeting of the ABI Commission on Consumer Bankruptcy. We have assembled here a number of our commissioners and a couple of members of the commission's committees to listen to the speakers who want to address us, particularly on issues that are involving local practice. That's the unique opportunity that we have at this particular ABI conference. Before we hear from our speakers, though, I would like each of the people at the dais here to very briefly introduce themselves, and we'll start with Mike.
Mike Bates. I am in-house counsel with J.P. Morgan Chase in Dallas, Texas. I support the consumer bankruptcy operations for our mortgage lending department.
Brian Shaw, Shaw Fishman, Chicago.
Ron Peterson, Jenner & Block, Chicago, and the newly minted president of the National Association of Bankruptcy Trustees.
Bruce Markell, I teach here at Northwestern.
Bob Lawless, I teach at the University of Illinois.
Gene Weedoff, I am a solo practitioner in bankruptcy appellate work.
Mike Miller from the firm of Heavner, Byers & Miller.
Jim Haller from the Haller Law Group in Lincolnshire.
Ariane Holzschlag, humble consumer bankruptcy attorney.
Wendell Shirk, humble solo bankruptcy attorney.
Okay, so now we turn to our speakers, and they are presenting their information to us in panels. The first panel is going to be Judge Thorn, Judge Baer, and Nathan Delman, and we will hear from them, I hope, in that order.
Okay. Well, my name is Debra Thorn, and I am one of the newer bankruptcy judges. I took this job after practicing 30-plus years on the business side of bankruptcy. So I've had a learning curve, but I've also had a special opportunity to look at what happens in consumer bankruptcy cases. In my former role, I used the bankruptcy code as a tool for business debtors to reorganize by improving their balance sheets, their operations, or liquidating assets through either a Section 363 sale or a plan. Creditors played an active role in negotiating resolution that was fair to them, while the debtors obtained breathing space and a fresh start. And this was access to justice, in my mind, in the Chapter 11 sphere. In my new role, I've observed that the bankruptcy code does not always provide the same opportunity for a fresh start for consumer debtors. In fact, there are many more hurdles that consumer debtors must face when making efforts to obtain a discharge because there's simply not the same tools available to them, and it also makes it very much more likely that creditors will not be paid because the case will fail. And this is especially true in Chapter 13s. Daily, I'm discovering the difficulty that consumer debtors have when obtaining a discharge through 7 or 13. And I hope the Commission will consider some of my suggestions, which may make access to justice a little bit more possible for consumer debtors. First thing I wanted to address was, I think that, and this is not in my written materials, and I apologize that I forgot to put this in there. Oh, and the other thing I wanted to say before I go on is I wanted to thank both Taylor Swart, who's my extern from Northwestern, and Ian Folensby, who's my law clerk, for their observations and their help in preparing my comments. The first suggestion I have is that the definition of current monthly income should be changed in 10A-B. 10A-B excludes Social Security benefits, payments to victims of war crimes or crimes against humanity or domestic terror. I think that included in this exclusion should be earned income credit. The case law concerning whether earned income credit can be should be included, whether that when it comes in the form of a refund, whether it should be turned over to the Chapter 13 trustee, is all over the board throughout the country. In a recent decision that I wrote that's now on appeal to the 7th Circuit, I noted that, and Judge Doyle in a companion case, the Morales case, noted that in some courts, the court stays completely away from earned income credit. Other courts, they have a cutoff. If you get up to $1,200 or you get $2,000, you can keep it, and the rest goes to the trustee. In this district, we, until a couple months ago, had 2 different methods of handling tax refunds. Some people were able, if they had one trustee, to get $2,000 that they could keep, others none. And then during the season of tax refunds, we had 1 million motions for modification. So it took a lot of the court's time. Earned income credit is clearly there for people who are very poor. And the budgets that people live on in Chapter 13 when they're below median, I don't know. I have no idea how they do it. And then largely they don't do it and their plans fail. So it seems to me that one way to make it more possible for both creditors to get some money in a below median Chapter 13 and for debtors to have some hope of success would be to allow them to keep earned income credit. And I think the way to do it is to change the definition in 10A-B. The next thing I wanted to address were Chapter 7 attorney's fees. Recently, ProPublica and Professor Lawless and some of his colleagues demonstrated that many times debtors are going into a no money down Chapter 13 because they can't afford, I have 4 minutes, okay, I'm going to go through. They can't afford to pay the filing fee in a Chapter 7. And I think the way to address this, and I won't, and most of it's addressed in my paper, is that these fees should be made perhaps non-dischargeable. You could pay them in installments. Maybe you don't get your discharge till after you've paid them, but there should be some way that somebody who is really entitled to and needs Chapter 7 relief is able to pay those fees and proceed in a 7 instead of going into a 13, which may take them 3 or 5 years. And the next thing I want to address quickly is credit counseling and financial management course. I've always thought this was really a hurdle that made it very difficult for people. I see all the time people who don't understand when they're supposed to take it. Case law is a little bit split of whether you have to take it before you file or that same day. But at any rate, people stumble, and I'm not really sure what the value is. So recently, I decided I would take the test, or would take the course. So I signed up for the credit counseling course, and I did it pretty quickly in 18 minutes, and then realized I had to be on that course for 30 minutes. So I set my watch, and I ended it at 30 minutes. And then I got comments back on the budget that I submitted that perhaps I should obtain a roommate. I discussed that with my husband, and he wasn't particularly interested in us getting a roommate, but that's the kind of advice I gave. And can you imagine if you are a minimum wage worker and you take this, which is basically the same as doing your I and J schedules, and all of a sudden, I mean, you're getting ridiculous suggestions when really you don't earn enough money and you are really, really poor. So I just don't know what the purpose is. I think it's just a hurdle that was put there to make it harder to get a discharge, so I would get rid of both of them. The final thing I will mention, and then the last point I have is really in my paper, is that I think the debt limit in Chapter 13 should be removed. There are many times where somebody ends up having to turn into 11 when really all they're looking for is the structure that a Chapter 13 plan will provide. I can't believe that the Chapter 13 trustees wouldn't want people with a little bit higher income coming in because they'd get probably a better commission. But it would really provide that structure. I'm not saying that people couldn't go into an 11, but it seems like having that ability to stay in a 13 when perhaps it's student loans or some other type of debt that has made them not eligible for that kind of relief. The final thing I addressed in my paper is Section 521I, and I think that's almost too complicated to explain orally. I tried to do it the best I could in writing, but this section does not make sense. It has an automatic dismissal if you don't make your papers filed in full and complete within 45 days, but I have never figured out where that magic happens, and it really removes discretion of a judge. There might be a pro se debtor who just didn't understand this one form or didn't realize that they had to have all those papers together when they handed it to the clerk. So it seems like removing that discretion really doesn't promote justice, and I would certainly suggest that the commission look at that and make some sense. And I'm happy to answer any questions you have.
Judge Thorn, you mentioned about Social Security.
We'll hold questions to all the panelists have talked because it might be that they interact, they interrelate.
Good afternoon. I'm Judge Janet Baer here in Chicago, Debbie's colleague, and I too came from big law like Debbie did. I will admit I never ever opened the code to see Chapter 13 until I got the job. And I really feel that our job as bankruptcy judges is to help people through the process, not put up artificial roadblocks to prevent them from or make it more difficult for them to get through the process. Having said that, I want to address 3 different points today, and my first one is picking up exactly where Judge Thorn left off, and that is the debt limits for Chapter 13. Frankly, it's an artificial deadline that does not have any real usefulness. I have a case, which I'm going to talk to you about in a little bit, where the debt limit is an issue. And so I looked at the legislative history, and it's kind of interesting. There are 2 rationales given for the debt limit when we looked at the legislative history. One of the rationales is they wanted to set a debt limit so that folks who are mom and pop businesses or own maybe a little apartment building or something knew that they could file 13, that they didn't have to file 11. The other rationale is sort of the opposite but the same, which is, oh no, the debt limits are set up so that big companies or people with major investments cannot file a 13 and have to go to an 11. So it's kind of the same part of the same coin. Well, I'll tell you, no Chapter 11 lawyer who has a business would ever want to go near Chapter 13 to reorganize that business in 13. You don't have to have numbers out there to tell them when they can and can't. The code itself is very clear, and it's very clear what 13 is for. It's for your regular income earner who's having a hard time making their mortgage payments and paying their bills. It's not for somebody who has a real legitimate purpose that needs to be reorganized. And between the bar who can police this by advising their clients correctly and the judges who get these cases, we can figure out which ones should be 13s and which ones should be 11s. We don't need an artificial debt limit. Leads me to my next point, which is student loans, which also involves the debt limit. We have a system today where we have higher education at outrageously crazy expensive prices, and there's a lot of money out there available for people to borrow in order to go to school, both at the government level as well as private loans. And it is very, very easy, frankly, for someone to run up an incredible amount of student loan, and then, of course, they're stuck. I had a situation recently of a debtor filing a Chapter 13 case. And it's a situation that really I want everybody in this room to hear about because it's important to note what can happen. I have a young man in his late 20s who recently filed a 13. He's employed on a full-time basis in a tech-related job. He actually works as a genius at, like, the Apple Bar. He makes a little over $40,000 a year. He's single. He has an apartment in the suburbs, $850 a month in rent. He has an old car, no debt on it. He has about $22,000 in credit card debt that he's accumulated over the last number of years. He has an undergraduate degree from a fine liberal arts college in something like diversified studies. And he has a graduate degree in television and film from one of the best schools in the country. In connection with his education, this debtor has, wait for it because I'm not kidding, $569,000 in student loans. Of that, he has $374,000 owed to the federal student aid agencies and $195,000 for private loans. His father is the co-signer on all of his private loans. Among his assets, he does list a number of scripts that he's written. Unfortunately, he is thus far not Steven Spielberg or Aaron Sorkin. He hasn't sold those scripts. He's currently paying his federal student loans under an income-based repayment plan. He's paying 10% of his discretionary income for 25 years. He doesn't have any specific arrangements that are particularly helpful with his private loans right now. He filed a Chapter 13 to get some relief on the private loans, deal with his credit cards, and protect his father, who's the co-debtor in all these private loans. Obviously, Chapter 13 is not going to discharge these student loans, but he's struggling mightily, doing everything he possibly can, and he's just not making it where he's at. Maybe someday he'll file an adversary to get a hardship discharge, but with the way the hardship discharge rules work now, it's really questionable whether he'll get that or not, whether he'd ultimately do that if he tried. But the fact of the matter is, what's happened here is the Chapter 13 trustee has moved to dismiss the case because he's over the debt limit. If ever there was a situation where a debtor should be in Chapter 13, this is that situation. And just because of what is an artificial debt limit, the court's being asked to dismiss the case. I think it's kind of a pretty good example of, number one, why the debt limit is so artificial, but number two, about the horribly, horribly compelling situation we have with respect to student loans and how something has to be done. Earlier we had a panel and Judge Carr was talking about perhaps, I think what he was proposing is perhaps judges should be taking a look at the undue hardship discharge provisions and being a little bit more thoughtful about what that means instead of the strict interpretation that Bruner might have and very difficult interpretation that Bruner might have suggested. On the other hand, look at the mess we've gotten ourselves into. How did this happen? It used to be that student loans could be dischargeable. There was a time limit, 5 years, then it went to 7 years, then it disappeared. Then, under BAP-CEPA, they included private loans. At the same time all of this happened, the price of higher education has gone up and up and up and up. And now we've made it more and more difficult for students to discharge their loans. Frankly, that makes absolutely no sense at all. So again, what I would suggest is that one of the ways we can fix this problem, or at least try to get some handle on it, is with the bankruptcy code. I would suggest that perhaps we go back to seeing whether or not some of these periods can be involved again in terms of how long, whether or not private loans should be in fact dischargeable, and of course look at the undue hardship. Whether it's judge-made or whether it's statute-made, it's something I think should be looked at very, very carefully. The last thing I want to say is also something that Judge Thorn touched on, and that is these crazy credit counseling requirements. These are artificial requirements. They do nothing. When somebody takes credit counseling, it's too late for them to learn all the things they should have learned years ago that got them into trouble. You can take credit counseling the day of. In fact, you can take it after you've actually filed your case that day, depending upon how you review the case law. But you know, at that point in time, it's too late. Any education you should have had, you should have gotten years ago. Now you've got to stop the mortgage foreclosure on your house. You've got to get your car out of the impound lot. You've got to deal with the fact that you've lost your job. It's simply too late. I would suggest that get rid of, and instead we use the time, the energy, and money to devote ourselves to things like volunteering for care and getting out there and teaching people. Or how about using that money and getting the help desk more help to help folks where they really need the help? Thank you.
Okay, well, now it's time for me. All right, okay, so I am Nate Delman. I am an attorney with the Sunrise Law Firm. I represent consumers in Chapter 7s and Chapter 13s. In addition to that, it is worth noting that the firm I work for, we do represent a very substantial percentage of all the consumer filings in the districts we practice. So some of my comments are coming from the perspective of someone who deals with a high volume of debtor work. The first issue I'd like to bring up is something where I kind of see the law heading, and maybe just society heading in general, and something that I believe it's time for the law to address, and that is electronic service to creditors. Now, in this district, since December 2004, if I'm not mistaken, attorneys have been required to file everything electronically. So that's about 13 years ago now, and that's the reality, is we're moving away from paper and towards everything being digital. Considering the number of clients we represent, the number of cases we have, every single day there's a large number of motions filed, and most of these motions need to be served on every single creditor in the case. It's a very large amount of paper, postage, and labor involved in just complying with the rules. Realistically, if you're a large creditor like Mr. Bates at Chase, there's no real quality that's added by getting it in paper than getting it electronically. I don't think it would be that difficult for these large creditors to set up dedicated email addresses to receive bankruptcy notices. I do think that this is something that should be a gradual change to the law. Certainly there are smaller creditors, like a doctor's office or someone who's a landlord who only owns one piece of real estate. It shouldn't necessarily be required to comply with this immediately, but it's something that needs to be done. This is going to be the reality eventually, whether it's 10, 20, 30 years from now. It's the way everything is moving. U.S. mail is antiquated. It simply is. And it's time to start the process away from service by mail. I'm not saying it needs to happen within 5 years, but it's time to get it started. Another thing that I wanted to bring up actually before is, in the written statement that is probably going to be available on the ABI website, I was educated in the last panel, and I was misreading a part of the new National Model Plan that does address the dischargeability after stay relief. I thought that it was just kind of keeping up with the current practice, which is if you have a mortgage and there's stay relief, that it wouldn't be modified under 1328. But apparently that's been addressed. So if anyone wants to, that was written. I just want to say that written statement was done by an ignorant man who no longer exists. There's a new, wiser man in front of you today. So if anyone can disregard that, and people who aren't here, I guess they're just going to think what they will about me. Okay. So I'm not going to do that part of my speech, basically. Thank you, new model plan, for addressing that. Although I would say that post-confirmation, stay relief, with real estate, yes, that's correct, but I would also think that it might apply to vehicles as well, but that's a little more of a drastic argument, but that's a story for another day. Okay, on to my next thing. Section 525. Section 525 purports to provide debtors protection from discrimination against employers. The language is there, and the language looks convincing, but if you really look into the case law, it's a pretty slippery case to try to prosecute your employer for terminating employment or discriminating against you on the basis of filing a bankruptcy. It also doesn't provide any sort of private right of action, at least not explicitly in the statute. There is some case law out there where people have been able to use 105 to do it, but it doesn't have anything like 362K, which does provide a separate private right of action. There are cases where people do not file bankruptcy because they are afraid of retaliation from their employer. And certain times, these are cases where there's not even anything that's really germane to their responsibilities that has to do with financial management. It's just a general idea that, well, if you're filing a bankruptcy, you're not an upstanding individual, and that's something that the code needs to protect against. So I would think that 525 needs to be rewritten to make it clear that there is a larger amount of behavior that is unacceptable by employers, and they cannot discriminate. They cannot discriminate on the basis of filing a bankruptcy. Another thing that I'd like to bring up that I know other people have brought up at some of these other hearings is, well, I know there's issues with the schedules, but the most glaring example to me, and I know other people brought this up, is Schedule D, E, and F only listing 3 creditors a page. Now, I had one case, and this is a bit of an outlier, where Schedule F was literally 75 pages long. That's a lot of paper. And if you take into account that last year there were about 800,000 bankruptcies filed, and some years there's over 1 million, only 3 creditors a page ends up being definitely at least a forest that could be avoided if you made it what it used to be, which was far more. And if you look at all the information on Schedule D, E, and F, you put in some sort of graph or some sort of spreadsheet, you could easily get 15, 20 creditors a page. It's just something that there are many complaints people could have about the schedules. I just think that's one that's just a simple one that can be fixed. Also, another thing that I do encounter practicing consumer bankruptcy, for good or for bad, a lot of clients come to me because of vehicles and debts associated with vehicles, problems with vehicles. One issue that I do see time and again is in a chapter, someone files a Chapter 7 because they've got a lemon and they don't have any, the lemon laws didn't cover it, and they've got a large loan and they just want to get rid of this car. It doesn't work, they owe a lot of money on it. So they do a statement of intent to surrender it, and the creditor knows it's a piece of garbage and doesn't want to go through the effort of getting the vehicle either. They don't want it. They don't want, they're going to have to pay someone to go get it. They're not going to get anything for it. It's not worth it. So then they're left with, they've discharged the personal liability loan, but they've got this hunk of metal that they need to take care of still. They need to make sure it's parked legally, they need to make sure there's stickers on it, and they're going to start getting parking fines, and it's going to frustrate the fresh start that they should get. So I don't know, I don't have a great solution for that. Perhaps the court fee for a motion for relief stay could be lifted or waived in the case where the statement of intent calls for surrender. But there's got to be some sort of mechanism that the bankruptcy court can have to allow debtors to shed these vehicles. Okay, so I'll wrap it up there.
Thank you. Questions? If you don't mind, I'd like to ask one of Judge Thorn. When you look at the definition of income in Section 101, do you think that Social Security income should be treated differently than other income that debtors get?
Well, the code provides for that right now.
Yeah.
Now, most people, many people who appear before me voluntarily use their Social Security to pay creditors in a Chapter 13 plan. And I'm not saying that somebody couldn't use their earned income credit if that was one of the only sources. And for most of these people who have it, it's pretty much it. They're very minimum wage debtors. But there's, the way we've approached it is the prorating expenses against it, which is sort of, well, it's not a terrible solution, but it's certainly unequal around the country. So I think that would be one way to level the playing field for all. These are mostly below median debtors to be able to keep that. The federal government has intended that to help support people who needed the support to buy groceries and to pay for clothes for their kids. So I think it should be treated the same way as Social Security is currently under the plan.
Judge Thorn, noting that we celebrate Veterans Day today, is there any good reason why disability payments that most people incur under Social Security are not counted for Chapter 13 purposes, but if somebody suffers the same injury defending his country, the payments he receives from the Veterans Administration must be included? Is there any justification for that dichotomy?
I would think that could be treated the same way as my suggestion on earned income credit.
Yeah.
For the Chapter 13 trustee to take that money to pay credit card debt just seems absurd. That's the federal government said you need this money because you've served your country, you're disabled, just like you're poor, and you should be able to get the earned income credit. That's what we put it in the code for.
If I could inquire and address this question both to Judge Bear and Judge Thorn, in terms of removing the debt cap, one of the rationales that's been advanced to this commission is that the debt limit is in exchange for creditors losing the vote. So in Chapter 11, creditors get to vote on the plan. In Chapter 13, they do not. Do you believe that if the debt limits are removed entirely, that creditors would be unduly burdened or face an undue hardship there?
See, I think you're really mixing two concepts. What Chapter 13 is meant for versus what Chapter 11 is meant for is so very different, and the nature of who the creditors are is so very different. In a typical Chapter 13 case, whether or not you've got $200,000 in debt or $400,000 debt, you've got the same kind of debt. You've got consumer debt. It's a statute for consumers. It's not a statute for commercial creditors. It's not a statute for people operating commercial businesses. So I don't think that's a particularly good rationale for the debt limit.
Although there are something like somewhere north of 25,000 business 13s filed a year, which is 3 times as many Chapter 11s filed.
But I'm assuming that those are more,
It's mom and pop.
Yeah, you've got an apartment building.
But mom and pop still have debts, right?
Yeah,
True.
but they're DBAs. It's not a corporate
Well,
entity.
no, obviously it has to be
Right.
for 13. But there's some notion that some people have kind of gone the other way and said, we need to remove the eligibility limit that it'd be a natural person, have small businesses come into 13. What you seem to say is 13 is not very good at all for that, and it should just be strictly a consumer.
No, I think 13 is fine for a small business owner, like a mom and pop grocery store, like a debtor who has a 3-flat and lives in one of the 3. That's a fine reason for 13. 13 is not meant for the debtor who's got 3 apartment buildings and a shopping center. That's what it's not meant for.
I think we have time for one more question before we go to our next panel. Anyone?
To both judges, there seems to be two problems with the debt limit in 13. One is it's completely arbitrary. But the other thing is, like a lot of the bankruptcy code, it hasn't adapted very well in the last 20 years. And I'm not just talking about incremental bumps, but it hasn't been adapted to address the situation that arose in your case, where you've got people who regularly show up with 6 figures of student loan debt. I personally don't think it's really reflected the historical last 25-year increase in the amount of housing costs
And it's
and
regional,
mortgages.
too. It doesn't reflect the regional.
No, and there's nothing, and that's a problem throughout the bankruptcy code. That nothing. I mean, other than the means test, there's a lot of things in there that have no reflection on the fact that in some places it costs 4 or 5 times as much to live as it does in other places. But going back to that, if could there be a middle ground where someone actually sits? Could a middle ground fix your problem? Could a middle ground fix the problem where someone still puts the debt cap limits in there, but someone actually sits, someone who, I don't know who that would be at this point, but somebody sits down and actually makes a real educated guess, so to speak, of what those debt limits should be based on what type of consumer debt is showing up and what type of small business, I mean, to some extent, consumer debt based on small businesses showing up.
Well, it's sort of like, where do you want to put the discretion? Do you want to have a debt limit but give the court discretion? Or do you want to have no debt limit and give the court discretion to throw them into an 11 if they don't belong?
And the reason why I'm asking that question is I'm guessing that the view of the people in the room on where that discretion should lie is unfortunately a lot different than the people who've been telling our judges that they should have less and less discretion over the past 20 years.
Likely.
Yeah.
Okay. Well, that will have to wrap it up for this panel, and we'll look for our next panel of speakers, but thank the ones who have participated in this one. We're going to be hearing from Mr. Leibowitz, Ms. Foley, Mr. Yen, Ms. Bryan.
No.
Nice presentation.
And we'll ask the speakers to present in that order. So, Mr. Leibowitz, you first, if you would, then Ms. Foley, then Mr. Yen, then Ms. Bryan.
Can you all hear me pretty well?
Can you pull the microphone a little bit?
Is this it? Can you hear me now? Yeah. All right. Well, first of all, I want to thank you all for inviting me to. I want to thank you.
You're done, David.
Thank you. We good? Yeah. Okay. Well, I want to thank you all for inviting me to speak before you. I consider it to be a real privilege to speak with you in such an important occasion, and I really do take this seriously. Many of you know me, but just to briefly introduce myself, I have a fairly unique background, and I spent the first 20 years or so of my life practicing in the commercial sphere. I represented banks here in Chicago nationally, represented large debtors, both on the creditor and on the debtor side, a lot of Chapter 11 work. And then in 1999, I refocused my practice, really completely rebuilt it from scratch, and built a consumer bankruptcy practice. And a little bit differently than Nathan's, it was not a high volume practice, it was a high content practice. And so a lot of people would refer difficult Chapter 7s and Chapter 13s to me. So I've been doing that for the past 15, 20 years through my Lake Law firm. And for the past 4 or 5 years, I've been fairly actively involved in another venture completely different called Upright Law, which is a national consumer bankruptcy firm representing people all over the country using technology, using internet, using distant ways of communication so as to afford access to justice to people in remote areas. And so over the past 43 years, I've been a trustee as well for 25 years. So this breadth of experience has given me a relatively global perspective. And I'll tell you that over the past 43 years, I've tried to think about the right comment to put the session in context. And Ferris Bueller came to my mind. Ferris said, life moves pretty fast, and if you don't stop and look around once in a while, you could miss it. And this is an important point. When things are moving fast and you don't stop, you lose a global perspective. And what I want to try to offer you today is a global perspective I've gained through 43 years of practice, as well as practicing locally in Illinois and in Wisconsin and in Arizona, where I have been admitted over the years. You know, the bankruptcy code started, at least from my experience, in 1898. And 40 years ago, we got the bankruptcy code. And just 11 years ago, we got BAPSIPA. And the world has changed fairly drastically in that time period. Things which worked in 1898, we know did not work any longer by 1970s, 1979, I guess it was. And I think that we can take stock in the fact that things that worked or even were thought to work in 2006 do not work in 2017 and will certainly not work by 2027. I think one thing that the Commission has seen in the past is that while one size does not necessarily fit all, uniformity helps. And the Model 13 plan is going to cause a lot of people some angst, but I think the model plan is going to help. I, for one, couldn't help but notice the distinctions and the discrepancies between how things are handled in Indiana and in Illinois and in Wisconsin. Why? Well, it happens that I'm admitted in all three of those jurisdictions, at least federal. I've practiced in all of them. And it takes some adjustment to change from Illinois to Wisconsin, especially in a Chapter 13 context. The forms of motion are different. The forms of practice are different. Things are different. Why cannot we have a little greater uniformity in practice? I think that it would be a wise idea to have a national review of local reviews. I think, rules, I should say. I think that the Commission should consider what the best practices are. And then we should endeavor to make the local rules uniform to the fullest extent possible. You know, Bankruptcy Rule 9009 now mandates the use of official forms. But for practitioners in multi-state areas, not just upright law, which practices nationally, but for people in New York, New Jersey, tri-state area, Philadelphia, New Jersey, Delmarva area, around Washington, D.C., we here in the tri-state Chicago area, Kansas City, all could use the benefit of uniformity, because the distinctions from one district to another don't make sense. I want to echo the comments that were made earlier by Judge Thorn, I believe it was, about the post-petition payments for attorney's fees. We have the idea of post-petition attorney's fees for Chapter 7 attorneys goes well beyond the issue of how we get paid. Studies have shown that poor people, particularly poor black people, are steered into Chapter 13 because they can't afford to pay attorney's fees. And Chapter 13 is not the best alternative for many people. The studies are uniform on that. Now, we know that Lamy says you can't do it. We know that Judge Weedoff and others have suggested workaround for the pre-petition and post-petition payment of attorney's fees, and we know that it's fraught with challenges, ethically and otherwise. And we know that uniformly around the country that it's not permitted. It should be permitted, because debtors should not have to make the choice of Chapter 7 or not Chapter 7 based upon how they can afford to pay their fees. Make it non-dischargeable and let them pay. Now, I would like to talk also about the question of credit counseling, especially pre-petition credit counseling. The judges are too polite to say it. It's stupid and it is cynical. The reason it's stupid and cynical is seen in Section 504K, because the only benefit that anyone can get from consumer credit counseling is the idea that they can get some kind of a potential cause of action for creditors that don't obey some kind of a pre-petition credit plan that is going to be put out. One case, and one case only, has decided such a thing and found it was not going to happen. You can look at the Hayes opinion, which I cited. This is stupid and foolish. Now, if you're going to have pre-petition credit counseling, let it be about the different kinds of bankruptcy petitions that are available. Let it be about the availability of Chapter 7 and Chapter 13 so that creditors, you can make an informed decision about what kind of case you want to have. The materials that I've had talked about that in greater detail. I think Bankruptcy Rule 4002B should be expanded so as to allow for greater uniformity around the country. Right now you have tax returns, bank statements, and pay stubs. Uniformly around the country, different trustees, different courts have laundry lists of things that are required. Let's have a uniform laundry list, and anything beyond that, let it be based upon a Rule 2004 examination. Again, the materials go into that in greater detail, but it shouldn't be a separate laundry list based upon the trustee. It should not be a separate laundry list based upon district. Very important is access to justice. Video conference availability to 341 meetings, I think, is critical. Right here, we have sponsorship of this place by court call and says you don't have to show up to court, get court call. Why is it that debtors should have to travel hours to get to a 341 meeting at a remote location? Yesterday, I drove from here to Rockford to a 341 meeting because my debtor happened to live in the east end of McHenry County, and she had to drive an hour and a half to get there as well. Stupid. She should have had to have, she could have shown up by a video conference. And right now, the U.S. trustee will require you to show up in one of their offices to be sworn and to show your identification. I can't believe that there would be, in this day and age, more reasonable ways of authentication of the identity and bona fides of a debtor and avoid the need for transportation. And in places like Arizona or Montana, much more so. Echoing Nathan Delman's comments, is a good time to have electronic signatures on documents. Everything's got to be signed, but nothing in the code says how it has to be signed. And I will submit to you that requiring a wet signature is every bit as archaic as perhaps a plume in the Supreme Court. No one's going to be signing anything with a plume in the Supreme Court any longer. And does it require a wet signature when some kind of electronic authentication could work, makes sense. So those are the main points that I would like to mention to you. I think that the Electric E-Sign Act shows plenty of authority for signing things now, and I think that, as Nathan said, for electronic signatures for creditors, electronic signatures for debtors make a lot of sense.
Thank you, Mr. Lieb. Ms. Foley?
Thank you, Your Honor, and thank you for allowing me to testify today. My name is Rachel Foley. I'm a bankruptcy attorney out of Kansas City, Missouri. I am the co-chair of the Midwestern Bankruptcy Institute and NACBA's Missouri co-chair for the state rep. I would like to speak to you today regarding reverse mortgages in the intersection of 3002.1, or the non-intersection of that particular section of the bankruptcy code. Reverse mortgages began in 1961. In 1989, the FHA started getting involved in insuring those reverse mortgages. In 2010, 10% of our population were 65 and above, and the mortgage product, you must be 62 and above to be eligible, among other requirements. In 2020, it is estimated that 56 million people will be in a reverse mortgage. This is a 40% increase from 2010. In trying to discern whether or not there's a foreclosure quotient in these HECM or reverse mortgages, there had to be a Freedom of Information request when Mr. Mnuchin became involved in the political climate. During that, it was disclosed that April of 2009 to April 2016, there were 41,237 foreclosures on these reverse mortgages, which could be the death of a borrower or the non-eligibility of the spouse, but foreclosure is just the same. The mortgage continues, a reverse mortgage will continue until such time as somebody passes, it's paid back, or the property is sold. And this is in particular, what I'm looking at, the issue are the defaults. And the defaults are related to property taxes and insurance. When somebody takes out a reverse mortgage, now they are required to take counseling. Before the mortgage letter of 2015-11, the counseling was kind of sporadic. They were told that they had to pay back the taxes and insurance along the way, and that they had to maintain the property as well. So as we move along, and particularly in the last couple of years, I would say from 2014 on, and especially when mortgage letter 2015-11 came out, the reverse mortgage lenders started contacting the borrowers saying, you are now behind. HUD requires us to recoup all corporate advances, and we can't carry you on the books for more than 5 years. And so they were threatening people with the foreclosure and throwing our senior citizens out of their home. When going through this, At that time, it was mandatory that you had to bring back the default back within a 5-year period. So at that time, if you couldn't get a family member to give you money or you couldn't qualify for this very stringent loss mitigation process, they were going to throw you into a foreclosure. Hence, we started putting people into a bankruptcy because we thought, okay, bankruptcy will save this. You have 5 years to pay back the taxes and insurance. We'll restructure you, get you on track, and keep that going. So with that, the Rules Committee promulgated, the Bankruptcy Rule Committee promulgated 3002. And we thought this was a godsend because it would encourage transparency on both sides of the aisle. The mortgage lender had to disclose what fees and costs were being assessed against the loan, and the debtor had to make sure the loan was current. Especially now, if you want a discharge, you have to make sure your mortgage is current before you get the discharge. So I come to the end of my first reverse mortgage client here within the last 6 months, and the trustee filed the notice of final cure under 3002.1 and says, I don't know what's going on in the mortgage basically because it's being paid direct. I filed a response, say she's current, not a problem, we're eligible for discharge. Lender says, we've advanced corporate advances and you've got to pay it, otherwise you're not current. In those advances were properties taxes, real property taxes. For the state of Missouri, we have real property taxes, and of course the force-placed insurance that was put in place for a long reason. But my debtor was paying through the senior quad program, and that allows her to pay in 4 equal payments through the year. She was current on that. Deed of trust says you can only participate if you don't take a lien superior to ours. We don't grant a lien in the state of Missouri until after 3 years. She was never at that point. In addition to that, in 2017 alone, there were 2 appraisals, one on April 10th, 2017, one on July 7th, 2017. She was charged $101.25 for those appraisals. That works to be a charge, $810 for those appraisals. That breaks out to a rate of $101.25 per day during that span. She was being charged for appraisals that do not or should not be charged back to that client. Bottom line is 3002.1, I found out during this service, does not apply to that because the law or the code specifically states that it's only applicable to the plan that provides that either the trustee or the debtor will make contractual installment payments. And that kicks us out of 3002.1 because there are no contractual payments due and owing. Even though I made the argument that if you do a corporate advance for property taxes and insurance and you work into an agreement through the Chapter 13 plan that it's paid back through an EMA, basically the court said that that is a non-starter with that. So my proposal to you is to protect the most precious part of our communities, our senior citizens who have earned the right to stay in their homes and remain in their homes, and that 3002.1 should remove that requirement that is tagged to installment payments. It says that it applies to the mortgages that carry a security interest. A security interest is offered and filed with the separate counties. When you take out a reverse mortgage for a deed of trust, it is recorded. Reg X and TILA both apply to reverse mortgages, and I come to you to say today 3002.1 should also apply to protect our senior citizens. Thank you.
Thank you, Ms. Foley. Mr. Yan.
Hi, my name's David Yan. My entire career in practice was in the legal aid environment, and over the years, more and more of my practice became bankruptcy. But because I've done other things, some of my suggestions may appear not to relate to bankruptcy directly. But my first suggestion is something that Nathan said, which is that Section 525 needs to be strengthened. My ideas, one would be that you have a right to attorney's fees. I mean, this is like a discrimination statute. I mean, it is a discrimination statute. The basis is bankruptcy. If you're discriminated against because of your race and sex, your attorney can get attorney's fees. And there is an active bar that represents people who are discriminated against. It's very difficult for anyone other than a legal aid attorney to represent a debtor or former debtor who's being discriminated against because of their assertion of bankruptcy rights. I also think that the protection should be extended to hiring decisions by private employers, and also there's to your intention to file bankruptcy. There's a Ninth Circuit case, Majewski, that said basically somebody said, oh, I'm going to go file bankruptcy to deal with my debts, and they said, don't come back, you're fired. I think that was stunning to me when I tell people at the help desk who are thinking of filing bankruptcy, I tell them, do not under any circumstances tell your employer you're going to file bankruptcy. You can tell them you have filed bankruptcy, but don't, and they're always stunned by that. In terms of covering hiring decisions, as Nathan said, people are saying, I don't want to file bankruptcy because this thing could happen to me, that thing could happen to me. It's hard to get a job. There are lots of laws right now on the state level regulating use of credit reports in hiring decisions, and that shows that the consideration of credit is someone's credit rating has just gone out of control, and employers should not be able to discriminate against you just because you filed bankruptcy. If it's relevant somehow to the job, that's a bona fide occupational qualification under Title VII law, and then that's fine. So a couple of my other suggestions are in that area are little technical fixes, changes to the Equal Credit Opportunity Act and the Fair Credit Reporting Act. From my perspective, it's seeing people at the help desk and also legal aid. A lot of people are filing bankruptcy, and they're using a 10-ton bomb to deal with a very small problem. One way to avoid that would be to raise the levels at which income is protected from garnishment. They've fallen behind quite a bit. And so the wage garnishment, I think, should be, instead of 30 times the minimum wage, it should be 40 times the minimum wage. And probably the minimum wage should be higher. And also, there's a rule about the threshold at which you can garnish someone's Social Security benefits was set at $750 in 1996. It hasn't been adjusted. That should be raised. I have a couple of things that are actually in the bankruptcy arena. And also, I think since Ms. Bryan was talking about the income-based repayment programs, they say, well, we let you keep up to 150% of the poverty level, and that's higher than the garnishment limits now. So in one area, the federal government says, yeah, you need more than this to live on, but then they're letting people be garnished and pushed towards bankruptcy or other extreme measures. In terms of judicial estoppel and the forms and the rules, a lot of people, especially non-bankruptcy judges, think that if you're in a Chapter 13, you have to file supplemental schedules when you get another asset. I mean, there's no question that is property of the estate. But right now, there's no rule that says you have to do that I can find. And if you had a rule, some places say, oh, you have to tell us about things that are significant or in a timely way. This is totally, well, I guess my first position is either the rule should say there is no other requirement other than what we already have in 1007H and 1019 in the rules. Or if there's going to be rules, they should say it, it should be clear. And I'm saying, I predict there will be none because it's totally unmanageable, but at least I would know what to do. Another one is that in terms of converting from Chapter 13 to Chapter 7, it says if you convert in bad faith, certain things happen. There's no procedure for determining bad faith. So Does the judge decide? Does the trustee decide? Does the creditor decide, after the case is closed, or does the state court judge decide? There should be something where there's a procedure. You have so many days to make an allegation of bad faith, and if not, it's good faith. Many things have been said that I agree with. I just want to say that, again, credit counseling is stupid. If you have it, though, dismissals for lack of credit counseling should not count against you in terms of serial filings for the automatic stay. Again, Judge Thorn and the equal earned income tax credit, I think that should be extended to all needs-based benefits should be exempt as IRAs are now. And that's the way you could do it. And finally, there's a little pet peeve, a very small pet peeve of mine is that in BAP-CIPA, Congress said that there could be waivers of fees other than filing fees, other than debtors filing fees. So if a creditor wants to file an adversary and is low income, I see these people at the help desk, or if there are other fees, it can be waived on a procedure by, that's the time. But the Judicial Conference has not, they're supposed to do it and they haven't. And I think this group could put some pressure on the Judicial Conference. They've had 12 years. It's about time that they come up with a procedure.
Thank you, Mr. Yen.
Thank you.
My name is Saskia Bryan. I was introduced before, so I'll spare you all that again. And I am surprised going to talk about student loans. This is actually a different issue than what was covered in the prior panel. So in Chapter 13 cases, student loans are treated as non-priority unsecured debt. And so they're lumped in with all the other non-priority unsecured debt, despite the fact that they are completely non-dischargeable unless you file an adversary or unless you get notice that someone has filed an erroneous plan and you don't do anything about it under Espinoza. But the problem with this is that, as other people have said, interest continues to accrue. The debt is non-dischargeable in general, and so treating student loans as non-priority unsecured debt causes all kinds of problems in terms of Chapter 13 plans. And because there are other sorts of debts that are treated as priority claims, such as taxes, alimony, child support, things that the government has said, essentially there's a public policy for treating these as greater, more important to be paid than other unsecured non-priority debt. My suggestion to the panel is to try and effect some kind of rule change that would treat student loan debt differently. If possible, to actually have it recategorized as priority debt, something that would meet both the priorities of saying that it's non-dischargeable, just like alimony, child support, etc., treats those things the same way. Also, so it's beneficial, obviously, to the student loan creditors because it can be included in the plan. Simultaneously, it's beneficial to the debtors because instead of just lumping it in with the non-priority unsecured debt and having to make payments to the priority claims and dedicate more resources to the priority claims while the student loans are still hanging out there in the background and completely non-dischargeable, it enables them to all be treated in the same manner. Even absence of rule change, there is the ability, I think Judge Carr referenced it earlier in the panel, to file a plan that separately classifies the student loans pursuant to 1322. My understanding is that there's a variety of case law on this because you do have to show that other non-secured creditors will not be adversely affected, and the mere fact that student loan debt is non-dischargeable is not in and of itself a reason or a sufficient basis, I guess, to separately classify the student loans. In my view, there are a lot of other factors about student loans beyond just their non-dischargeability that should allow for that change, should allow for a student loan payment to be treated as a priority debt in a Chapter 13. One other thing that has come up a little bit in my practice is that sometimes it can be difficult in a Chapter 13 context to deal with some of the available remedies that student loans have available to them, things that I mentioned before, like rehabilitation, consolidation, and then the income-based repayment plans. And so I've seen it's not uncommon, I think, for Chapter 13 debtors to just leave the student loans out of the Chapter 13 entirely. They don't make the payments to the student loan lenders through the plan. And there is now with the new form, there is the ability in the non-standard plan provisions to deal with income-based repayment plans, et cetera. Also to include provisions that allow for rehabilitation, because you're not permitted to do an income-based repayment until you are out of default. And I would encourage the Commission to think about all of these different ways that we can perhaps improve the administration of student loans. I have one final thing I wanted to just address that were not in my written materials, but partly in response to all of the comments that have been made about the Brunner standard. As you might imagine, I am kind of a fan of the Brunner standard, actually. However, I do agree that as of this moment in time, it does not allow for any real assessment of the differences in the student loans. And I think that there is a very distinctive difference between private and public student loans. Some of the things I didn't mention before, the federally backed loans, there's no creditworthiness test. If you make below a certain amount of money, you automatically get the loans. That's not true of private loans. It doesn't have to be true of private loans. The federally backed loans have caps. There's only so much you can borrow for undergrad. There's only so much you can borrow for graduate school. And so that is another means by which the federally backed loans are attempting to control this problem a little bit. And of course, the payment plan and the forgiveness that goes along with the payment plans under the federally backed loans. So I feel like if Brunner is to be addressed, one of the key factors that needs to be looked at is that there are major differences between the federally backed loans and the private student loans that are not just the mere fact that taxpayers are paying the federally backed loans, but because there are mechanisms in place that are designed to be a little bit more friendly to borrowers in the first place.
Thank you.
Should I make a comment?
No.
Which is the idea about making it a priority loan. I think a better way to address it would be to amend 1322A, which right now says that you can make a different class based on whether the debt was a co-signed debt, and to add it there that, however you define a student loan, that could be given different treatment. Because if you make it a priority debt, you have to pay priority debts in full.
I was going to make that
And in
simple.
5 years, yeah, that would be something that need to be addressed.
Now, there is an exception for domestic support obligations that are held by a governmental entity. They don't have to be paid in full.
Right.
So perhaps in connection with your suggestion regarding priority, there would be a similar exception to the full payment requirement for student loans.
And can I, Saskia, a follow-up question related to that? In your proposal, do you envision a distinction between the priority treatment of private versus the priority treatment of public? And the reason why I ask is because a lot of the reasons that you cited in your paper for them being priority really only apply to one of them.
I don't know what I think there are strong justifications to treat the two differently, but how you would fit that currently into a post-Bathsheba world, I'm not sure how you do that. I think from an ethical standpoint, I think they should be treated differently. I think that the priority, in much the same way that I think if you were to look at the dischargeability question, I think that there should be differences that you should take into account the differences between the private and the federally backed loans.
I'm going to use the more diplomatic term moral, but yeah, I get it. Okay, I was just curious.
I have a kind of a joint question. It goes to twice. The notion was brought up of moving claims which are currently either not dischargeable, non-priority into a higher status, one with attorney's fees, one with student loans. As to student loans, why are they that much different than any other non-dischargeable, non-priority claim like fraud or the like? Because those are just as important to the people to whom that money is owed, I think, as to the student loan. And as to the attorney aspect of it, I'm concerned, based on kind of my experience of 9 years on the bench, that there's a certain percentage of debtor attorneys, none who would be here, of course, because they don't come to conferences, but a certain percentage who would take advantage of that. And the resources that judges have to monitor, even though they have the ability under 329, to monitor what debtors' attorneys pay just would not be up to the task. I asked Ms. Bryan to go first.
Well, clearly there are other, and I think that's the point of some of the interpretation of 1322, which is that the mere fact that a debt is non-dischargeable is not in and of itself enough to classify it differently, to give it priority.
I've always thought, by the way, for below median, you could extend the plan longer and pay the student creditor in the last 2 years, but that's another matter.
So my argument with respect to student loans being different from other types of non-dischargeable, non-priority debt is that, again, it goes to this idea that the public policy behind it, the justification for making it non-dischargeable, but then also some of the factors that go into the federally backed loans, that the fact that there is no credit worthiness test,
You realize
et
in the
cetera.
60s that student loans were made student loans because they originally were grants and they were only made loans as a budget balancing effort by the federal government in the 60s, and then we just extended that because certain athletes and doctors took advantage of it. I'm not exactly sure that the roots of non-dischargeability for student loans justify everything that you're saying.
Well, that is true. Another part of that equation is that this was during the war on poverty, and there was a belief that people should be able to go to college regardless of what background they came from, and that the fact of applying a creditworthiness test to whether or not these individuals should be given money, or in this and later loaned money in order to attend college, didn't come into play. And so there are two sides to that. There is, yes, okay, fine, there used to be dischargeability, and then they got rid of that because there were a couple of random, supposedly outlier cases of people who were trying to, just game the system. And yet at the same time, Bruner being one of them, yes, although Roberson, which was decided in the Seventh Circuit, was not necessarily one of those, and that was in 1993. The fact is that along the way there became this public policy of, we want absolutely everyone who has any interest to go to college. And one of the more interesting things that have come up in another panel discussion was this idea that maybe not everyone should go to college. So I think the bottom line here is, for me, there are in fact a number of factors to student loans, to the debt, to the concept behind giving people this money and allowing them, empowering them, if you will, and you can say certainly that people age 18, 17 maybe shouldn't have that power, but empowering to make those decisions and take that money. And then as Barb mentioned in the statistics, there is still a pretty high percentage of benefit to taking out these loans. People who do in fact get degrees do wind up, generally speaking, with higher incomes.
We're running out of time, so I hope that other half of your question can be answered. That was regarding attorney's fees?
Well, I think the answer, Judge Markell, is that we don't want perfection to drive away goodness. I think the concept of a lawyer being able to make a decision that he or she trusts his client well enough that the client can pay post-petition is something that should be honored in general. I think that the alternative, which is that the creditor lies, cheats, and steals, and begs and borrows and pleads, and maybe stiffs this creditor or that creditor in order to be able to pay petition fees pre-petition because of the purity of a pre-petition fee, is really not particularly helpful to the system. I think the debtor needs access to bankruptcy right now a lot more than we need to have the perfection and purity of the debtor being paid pre-petition. I think that if there's a bad attorney, then 329 and other rules are available to address bad attorneys, but most attorneys are not bad attorneys and should be paid.
Okay, we have time for maybe 2 more questions from the panel here. Any? Then we have 2 minutes to get ready for our 1:30 program. Thank you all.